I want to ask Justin to talk for a little bit about his background and the kind of work that he does and the kinds of problems he can help people solve before, during, and after they start their work. So, Justin, do you want to just go ahead and start with a quick introduction to your background and your intellectual property practice here in the entertainment industry?
Sure. Well, first, I'd like to say thank you. Thank you for this opportunity to share some information. I am an attorney practicing here in Los Angeles. I've worked with filmmakers, independent production companies, authors. I've done transactional work. I've done litigation work for intellectual property infringement in federal courts, and I've done a wide range of work for unknown people to people who are who may be mainstream, and it's been very rewarding. I like to be involved in the community here in Los Angeles, and I really look forward to this phone conference.
So can you tell me? I know that a couple of questions that I want to make sure we mention to people right off the bat. First thing is that you have a company, and on your company's website you actually list all of the kinds of intellectual property and content related tort work that you do. Can you go ahead and give people the URL for your website so they can go take a look at it, maybe while we're on the call or right after, so that they know know the specific kinds of work that you do, like they have a list of it?
Sure. It's my business website is www.thesterlingfirm.com. That's TheSterlingFirm.com. And feel free to email me as well. My email is justin@thesterlingfirm.com. Great.
And then also I wanted to mention, because the reason that you and I met is because I attended one of the meetups that you actually hold, which a lot of times you have lawyers and legal representatives attending and speaking. And do you want to tell people the name of that meetup so that so that those people that are interested in attending those kinds of events will know where to go?
Mm-hmm. The meetup that I organize is called the Hollywood Entertainment Industry Meetup. It's been up and going for about, I would say, a year and a half, 2 years, and there's over 1,000 members, and they're professionals in all areas of the entertainment industries. We invite guest speakers to share any valuable information that could be helpful to our members. We've had executive producers, we've had Hollywood executives, we've had entertainment attorneys, we've had anyone from tax professionals for the entertainment industries. We've had a wide range. We've had personal development, coaches. It's been very rewarding, and I'm always open to suggestions for additional speakers.
Cool. And then you have somebody, I was particularly interested, you have somebody coming up. When's your next meeting? I think you have somebody talking about investment. Is that correct? Or talking about...
No, on March 24th, there will be entertainment attorney Gary Goldberger, and his presentation, he's spoken a few times in the past on different topics. He's spoken on reality television agreements. He's spoken on option agreements, distribution agreements. I think this presentation, it will be on distribution agreements. Let me just check that. I'm not sure. Let me just pull it up.
And I think you meet at Mel's Drive-In Diner on Sunset Boulevard in the morning, right? Cool.
Right.
All right, I just want to make sure, because I was pretty impressed by the number of events you have and the fact that you tend to have some really interesting people that are kind of hard to get a hold of to come in and talk.
Oh yeah, Gary's great. He's, I'm really looking forward to the next one. We've just had a really great presentation by Michael Praver on Film Funding LA
Mm-hmm.
about first money in film funding options. Gary Goldberger, Thursday, March 24th at 8:30 a.m. It will be speaking about the legal and business aspects of distribution.
Right, that's totally cool. That is excellent. Okay, I think everybody's actually on the call now. We are a very full house today, and what I would like to do is sort of move on to now that we sort of a good understanding of your background, and I'd like to go ahead and ask. I guess my first question is that there are a lot of it's come to me. I've sort of discovered that there's a lot of legal issues involved in telling true stories, even true stories that have actually happened to the person that's telling the story, whether they're writing them down or they're deciding to make a movie about one of their experiences. And I find it interesting that there's any legal issues at all. Like if I want to talk about John Kennedy having Marilyn Monroe as a mistress, or talk about what life in my family was growing up, don't I have the right to talk about anything that I want? Like if I know for a fact that it's a true story, or how does that work?
Mm-hmm. Well, okay. So like many things in the law, the answer is it depends. So I would say yes. However, it is a balancing between the filmmaker or author's First Amendment freedom of speech and the subject's individual rights. Everyone has the right to not have their reputation defamed, and everyone has a right to privacy, the right to not have your personal matters intruded upon. People also have the right to not have their name or image exploited for commercial profit without their consent. So that's known as your right of publicity. So there's three legal issues involved with telling a story about an individual, a true life story, a biopic. The three legal issues is defamation, right of privacy, and the right of publicity. So I'll take each one of those. I'll discuss them separately. Defamation is the unprivileged publication of a false statement of fact that injures another's reputation. It is a communication that harms the reputation of another so as to lower him in the opinion of the community or to deter third persons from associating or dealing with him or her. They expose that individual to hatred, ridicule, or contempt, or reflect unfavorably upon their personal morality or integrity. This is defamation. And one who is defamed may suffer embarrassment, humiliation, as well as economic damages, such as the loss of a job or the ability to earn a living. There must be a balance of interests between protecting an individual's personal reputation and the freedom of speech. That's always the competing interest, is an individual right versus the freedom of speech in this type of situation. The elements for a cause of action for defamation is 1, a false statement about the plaintiff, 2, the publication of the statement to a third person who understands the defamatory meaning of that statement, and 3, fault on the part of the defendant, which may be intentional, reckless, or negligent in regard to the falsity of the statement. I'll discuss that a little bit more in depth as I go on, because there's different degrees of fault that must be applied depending on the status of the individual that you're discussing. And then 4th, with every tort, there must be damages suffered, whether that be intangible, emotional distress, or economic damage suffered by the plaintiff. And because of that fault element, there are significant limitations on public officials and public figures to succeed with defamation actions, because they've attained that status of a person who can be commented upon in society. And as a result, a person who is a public figure must show the degree of fault known as actual malice. Actual malice is intent. Is a high degree of intent, or such as knowledge of falsity, or a gross reckless disregard for obtaining its truth. Go ahead.
So that recent case that just came out, or this recent book that just came out, that said Brando and some other and James Dean were having an affair, and says that it was a abusive relationship. So if it was the case that the person who wrote the piece knows for a fact that that's not true, even though the fact that he's writing about Brando and Dean, both of those people are famous and they are both dead. So is that a situation where you have to worry about defaming their character because they're dead? So who's going to file that cause of action? I mean, in other words, defamation. How can there be? Who's going to file the defamation claim? Like who?
Okay, I'll go into that a little bit further. But defamation does not succeed the death of an individual. It is a personal right. However, there are other rights that can succeed the death. Right of publicity. So again, and I'll discuss this later. The right of publicity it's also a balancing. Is what's being discussed commenting upon? All right, or is there an expression here so as to be protected by First Amendment free speech, or are they using that person's likeness or image to solely exploit the product? I'll discuss that a little bit later. But yeah, defamation does not succeed the death of the individual. So I'd like to go back and discuss what a statement of fact is. So in order for a statement to be considered defamation, it has to be a false statement of fact. There must be a distinction from statements of opinion. And statements that do not consist of facts, but rather are merely the views of the person making the statement, do not qualify as defamation, because the First Amendment to the Constitution, freedom of speech, protects freedom of expression. Statements of opinion are privileged speech and are not actionable as defamation. So you may ask, how do you know if something is a statement of fact versus opinion? That's always the question. Whether an alleged defamatory statement is an opinion or an assertion of fact is a question of law that the court will decide. And the court will apply certain tests. And one of the most known tests that the courts apply is the contextual test, which is also referred to as the totality of the circumstances test, which will consider factors such as the content and form of the communication taken in its totality, the circumstances surrounding the communication, and the ordinary meaning of the words that make up the communication. And what I mean by communication, it can also be the depiction, the portrayal, the photograph, which can be moving or still, and the likelihood and reasonable, understandable interpretation of the words, and the extent to which the words can be proved false or true by objective evidence. So that's what the courts will apply to determine if it's a statement of opinion protected by freedom of speech, or if it's an actionable statement of fact, something that's verifiable. We digressed a little bit, but talking about your question as to if you can make, films or stories about particular individuals, another right that you have to be concerned about is the right of privacy, the invasion of privacy. Everyone has a right of privacy that is based on the individual's reasonable expectation to be left alone. The right of privacy, however, the right of privacy is not absolute. Again, it's another balancing act with the First Amendment freedom of speech. And if the events are newsworthy and the statements are not protected by, then the statements are not protected by privacy unless you can show actual malice. Again, with that actual malice standard comes involved. A matter that is considered newsworthy, and here is the test for newsworthy, is whether it's a legitimate concern to the general public. In addition, the injury to an individual's reputation is not required to pursue a claim for invasion of privacy. So the individual's reputation does not have to be harmed in order to have a claim for invasion. Also, in contrast to defamation, truth is not a defense to invasion of privacy. True statements may still be the basis for a cause of action invading a person's privacy. Also, matters of public record are not considered private. So if a person voluntarily reveals private facts to others, they're no longer considered private, and in essence, the individual has consented to its dissemination.
Right. So I want to sort of make sure that that's clear. So if I have if my next door neighbor, the lady who lives next door, is having an affair, and I take photos of her and then I publish and I say this lady's having an affair, and she's not famous, and she's not like a rock star or something like that, then I'm invading her privacy because she has every right. She's not choosing to make it public. I'm making it public, and she just happens to live next door to me, and it's not newsworthy because she's not like a rock star who has 13 wives. So, and it's not a matter of public record in any way. So in that case, I'm invading her privacy. But if I was saying that a rock star or a television minister was having an affair, and he was famous and it was newsworthy, I mean, so it has to. There's some. Then it becomes whether or not what makes it newsworthy is whether or not the person is well known or a celebrity, or how can you know if it's newsworthy?
Again, as a public figure, the definition for a public figure is one who has obtained notoriety in the general public. It's a widespread notoriety. That's the legal definition for a public figure. So yes, someone who is well known in the community, and you can have different community standards as well. But your hypo there raises a couple different issues because there are specific legal causes of action for the violation of an individual's right of privacy, and those are there's 4 of them. 1. Public disclosure of private facts. 2, intrusion into seclusion of an individual, intrusion into an individual's seclusion or private matters. 3, misappropriation of a person's name or likeness. And 4, portraying a person in a false light. Okay, so those are the 4 main causes of action for the invasion of the right of privacy. The public disclosure of private facts, in order to recover for that cause of action, the matters revealed to the public must be, and here's the standard, highly offensive to the reasonable person, and the matter must not be newsworthy. Again, there's that standard of newsworthiness because it's protected by the First Amendment, freedom of speech, fair commentary, your right to critique. Public figures, celebrities, public officials, they have a more difficult time to showing an invasion of privacy, defamation. They have a higher standard because they put themselves out there. They put themselves out there in the public to be commented on. The second cause of action for the invasion of privacy is the intrusion into seclusion. In order to recover for this cause of action, of intrusion into a person's seclusion, solitude, or private affairs, the matters revealed must be obtained through an unwarranted means, such as a non-consensual videotaping or recording. This is kind of like eavesdropping or spying. The two required elements for intrusion into seclusion that you must prove in order to recover for this claim is 1, an intrusion into a private place, a conversation, or another matter, and 2, which is done in a manner highly offensive to a reasonable person. Again, whether something is a private place where you have an expectation of being secluded, there must be an objectively reasonable expectation of seclusion or solitude in that invaded place or conversation. Again, when we're discussing about privacy rights, it's a reasonable expectation to privacy. If you put something out there for everyone to see, then there's no reasonable expectation. Now, maybe if you're taking photos of that person having an affair, maybe if that person was taking that mistress out in public, and you're shooting pictures of them, there's no reasonable expectation of keeping that private there. It's not within the privacy of your own home. There's no reasonable expectation. However, there's still other causes of actions that you may go on, such as false light or misappropriation of name or likeness. I'll discuss misappropriation right now. A cause of action for misappropriation of an individual's name or likeness, which also includes their voice, their photograph, or any type of likeness. A famous case was Vanna White. There was a Samsung commercial many years ago where they had a mechanical robot that depicted Vanna White. There was a Wheel of Fortune wheel, and they said they were misappropriating her likeness. It wasn't her actual image, but it was her likeness that they were misappropriating. Now, this cause of action is similar to an individual's right of publicity, but the difference is that you can only be compensated for the harm that is suffered in terms of emotional distress, whereas the right of publicity compensates the individual for the commercial value in exploiting their name or likeness. And the right of publicity is generally only maintained by celebrities who have publicity value, who perform publicly for a living, who incurs fees for putting their name on products. They have a right of publicity, whereas an individual layperson or someone who's not a celebrity does not have much publicity value in their image or name.
So you can't go and take a picture of Robert Downey Jr. Drinking your eating one of your cupcakes and then use that as an advertisement for your cupcake, because you need to pay Robert Downey Jr. for an endorsement because he has a right to the commercial use of his likeness, correct?
Right. However, there's also another balancing act involved. Now, if the sole purpose is to exploit that image for profit, then you're intruding upon their right of publicity. All right. However, if you're using it as an expression, as a commentary, as some sort of opinion, there must be something attached to that image with commentary, because then it's protected by freedom of speech. And when you're balancing that, freedom of speech is very powerful. It's paramount. That's our First Amendment. That's a very powerful right. It's what this country's really been based upon, is freedom of speech, the right to comment against public officials, really. So it's a very powerful right, but it's not absolute. You have to balance it. So if you're solely using that image for exploitation, for commercial profit, then you're violating the right of publicity.
Are you gonna touch on what happens? Let's say that I grew up in a home that was very abusive, and then I want to write a story talking about my parents and my abusive brothers and sisters or whatever. And then do I have, in that particular situation, I'm telling a story that I know personally, but these aren't public figures; they're just people, and I'm making them notorious. So the only reason I ask is I've had multiple people. One of the reasons I wanted to have you on was because I've had multiple people come up to me in events and say, I'm writing a book about my family, or I'm writing a book about my relationship with my ex-husband, or I'm writing a book about my abusive father, or I want to do a movie, but they don't know where their right to tell their own story begins and ends. And they also don't know if they have to get life rights or buy life rights from these other people in order to protect their right of publicity and their right of their rights of privacy and so forth. So
Mhm.
I don't know if you're going to talk about that now or if you're going to talk about that later on, but that's a very specific case that I know multiple people on the call are facing.
Right, right. Well, I'll discuss. It as a general rule, the more releases you can get, the better. You want to be protected. You want to create that paper trail, and you want to get everyone to release any claims. You're safe. You're safer that way. You minimize the risk. But there's also, and I think that that hypo does touch upon the fourth cause of action for invading someone's privacy is when you portray someone in a false light. Now, a cause of action for portraying someone in a false light is similar to defamation. However, you don't have to. The plaintiff is relieved of the burden of proving harm to reputation. Rather, all that is needed is to show that the portrayal is highly offensive to the reasonable person, and it may expose that person to hatred, contempt, or ridicule in the public eye. What I also would like to discuss is if you're going to do a fictionalized story based on an individual and it's unflattering, you do have to have great care in not portraying that person in a false light. Because since that story is fictional, you know that those statements are not true. And so you could be, if there's ever a claim brought, the court may consider the story to be published with actual malice. And when you have actual malice, you could be subjected to punitive damages. A lot of these times when you're trying to get into, when there are claims brought, and a lot of times people ask me, what are the damages? Damages for invasion of right of publicity, or damages for invasion of right of privacy, and defamation are difficult to show. A lot of times you're at the mercy of the jury, but the bulk of many large jury verdicts, are that punitive damage element to damages. Punitive damage, I should probably say what punitive damages are. Punitive damages are damages that are granted in order to deter or punish an individual for conduct that is considered wanton, willful, or malicious. Let's see. I'd like to discuss the right of publicity, and then you can ask the next question. But the right of publicity is the right of an individual to commercially profit from their own name or likeness. The non-consensual use of another's name or likeness for commercial gain is prohibited. However, as I stated earlier, this right is generally only limited to celebrities who earn significant fees from performing publicly or by endorsing products. And we discussed this, that there must be a balancing act with the First Amendment, because a celebrity, by virtue of their notoriety in the public, is newsworthy and can be commented upon. Newspapers, newspapers, magazines, books, movies, plays are considered expressions of speech protected by the First Amendment. And by placing a celebrity's image on such a product, there must be a balancing of the First Amendment against the individual's publicity rights. Now, if it's on a product, the publicity rights are stronger. The seller of the product, again, must be making a statement or expressing an opinion about the celebrity. There must be some form of commentary rather than solely exploiting the name or likeness. Otherwise, there's no competing First Amendment concerns, and the right of publicity will prevent the unauthorized use of the celebrity's likeness. Now, you discussed earlier about a deceased celebrity. Now, depending on the state, some states have enacted laws that allow the right of publicity to survive the death of a celebrity. In California, there's Civil Code Section 990 that provides that the right of publicity survives the death of a celebrity for products, merchandise, and goods, but it does not survive for books, plays, television, and movies.
So that's why Marilyn Monroe, and Einstein, and Elvis can be, like, you can see their images and their likenesses and all kinds of things, because their right of publicity doesn't extend to fictional works. But if you were putting Marilyn Monroe's picture on a T-shirt, that would be a product, and that would be prohibited. Is that correct?
Exactly. Unless you work it out with the estate. They probably have some royalty agreements, licensing agreements in place. Because the heirs of the celebrity can enforce the right of publicity for up to 70 years after death.
70 years? 70?
70 years. 70,
wow.
Yes. Yeah,
Jeez.
it's pretty long, yeah.
So all of those Marilyn Monroe T-shirts on Hollywood Boulevard are either licensed or illegal?
They're probably illegal. However, again, if you're commenting upon it, it could be protected by the First Amendment, free speech. It's a balancing act. There must be some form of expression involved.
That makes sense. So it's the fact that it's free. So it's a question of speech versus a question of just using the image in order to sell the T-shirt. So if it's Marilyn Monroe, died too young, that's an expression of speech, or an expression of, talking about, how life is fleeting, as opposed to just using her image blatantly as packaging for a product. Like if you put on a Campbell soup can, Marilyn loves Campbell soup or something, that would be a violation of her right of publicity.
Oh, yeah.
Right. Cool. So did you want me to move on to the next question, or did you?
Yeah.
Okay, cool.
No.
This is, I think, a really common question that people, which actually relates to the same topic that the same people I know who are talking about these, telling their own life stories or telling the life stories of people that they know. It seems like on television there are stories where the stories actually say person X killed person Y, like all the coverage that was done on the O.J. Simpson trial, or and all the speculation that went with it. And it's not like O.J. I'm not sure the Nicole Brown Simpson's boyfriend really signed up to be a public figure, and yet he was sort of exposed pretty continuously, even though he wasn't a celebrity, never chose to be a celebrity. All he did was kind of get killed. So sometimes stories say person X killed person Y, or person A had an affair with person B, and the result is damage to a family. Or they'll take a court case and they'll take the transcripts from the court, and they'll actually use those to create the dialogue. And even though a lot of time what was in the court case, is that fact, or is that the speculation of isn't it speculation? Like the prosecution says, well, this is what we think happened, and or maybe this happened, and they have an alternative scenario. So, what are you allowed to actually take as fact, and actually expose? Like, are there any safe sources? If somebody has been found guilty in a court of law, can you take the transcripts and just do whatever you want with them in order to create a story based on facts? Because I think a lot of biopics are done that way.
Mm-hmm. Court records are matters of public records. So I would say if it's a matter of public record, there is no invasion of the right of privacy. Anything that's open to public inspection, there's no right of privacy.
And no defamation?
If the matters are determined to be true, then there's no defamation. Truth is an absolute defense to defamation. However, now in some circumstances, all right?
Yeah, go ahead.
in some circumstances, you may have to bear the burden of proving that the statement is true. So, and that may be difficult to do. Now, you can have court records supporting your assertion that it's true. That would be helpful, but it's you bear the burden to prove that the statement is true. There's also fair comment. Again, it's the free speech, and you have the privilege to comment upon another. But again, that's not absolute. And the statement must be about a newsworthy person or event. And it cannot be made with bad faith or abuse or, again, actual malice, knowledge of the falsity, or a gross, reckless disregard. Now, if you are relying on the public record of a court transcript, then I would say that you've satisfied your duty to discern whether the statement is true or not. That actual malice standard is difficult to meet. It's a high standard. It's beyond negligence. Negligence is the standard for an ordinary person to show defamation. That the person was negligent in making the statement. But for a public figure, that's not enough. You have to show actual malice.
So when people are buying life rights, if I'm doing a story about, let's say I'm doing a story about my family that's a member of some strange cult, and I want to talk about things that happened during the period that I lived in this cult, then if I get life rights from 5 or 10 people and I record their stories and they say, yes, this is what happened, is that sort of a preponderance of the evidence that says these 10 people say that this happened, so I'm saying that's a fact? Is that why you need the life rights, is to prove that is that what the life rights are?
Okay. Yeah. Life rights. Okay. Well, first, that would, what you just suggested about obtaining, it wouldn't be life rights, but from those individuals saying that something is true. It would just be a supporting statement, affidavit, or declaration that would be supportive to prove, to meet your burden to show that the statement was true. But life rights, all right, when you're discussing life rights agreements, so when you're purchasing the rights to make a story about another's life, it is actually a waiver from the party who may assert claims against you.
Oh.
All right? It's actually, life story rights are actually a release. Those are a release from bringing claims because you want to be protected against lawsuits for potential defamation, invasion of privacy, and violation of right of publicity. So in life story rights agreements, you may also negotiate the ability to consult with the individual's family members or heirs and have access to their personal information in their possession to create your life story for them. Now, if the subject of the life story is deceased, the need for a waiver of claims is less significant because, again, the causes of action for defamation and invasion of privacy do not survive the death of the individual. However, the right of publicity may or may not descend to the individual's heirs, depending on the particular state, the state law that has jurisdiction. And again, public figures must meet that higher burden of proof to establish defamation or invasion of privacy. They have to show that the statement was made with actual malice, that is, intent and knowledge of the statement's falsity or reckless disregard for the truth. In these life story rights agreements, there are certain terms that should be that are common. One of the terms is the extent of the rights, whether the agreement will include creating remakes, sequels, television series, merchandising, novelization, live stage rights, radio rights, whether the story, and then also this is one provision that may protect the individual that you're doing the life story. They may want to limit the particular time period of that individual's life, so that they may not want some embarrassing moments portrayed in their life story. So they may negotiate that, this life story is only contained to the period of 1972 to 75, or only contained to the trial that they went through, or only limited to their relationship with a particular person. They can limit it in that regards. Typically, also the extent of the rights, you want to let them know whether they can distribute the story worldwide or only limited in a particular geography. Typically, the buyer of the life story rights will want as broad a grant as possible, whereas the seller may insist on retaining or limiting certain rights. Another provision that you'll want in your life story rights agreement is the releases. So you'll want the releases of also third parties. If other individuals are portrayed in the project, those parties will need to release their potential claims as well. These parties may include the individual subject's spouse, children, friends, and relatives. A lot of times, if you're not able to obtain these releases from these secondary characters, you may have to cut them out, or you may have to fictionalize them if you can't get their release. And we'll discuss fictional characters later. Another provision in a life story rights agreement is the assignment of rights provision. So if the buyer of the life story will need to obtain financing, the rights may need to be assigned to a studio, a production company, or a network as part of the financing distribution agreement. So you have to negotiate in the life story rights that you are capable of assigning these rights in order to obtain that financing. Another provision is the option purchase provision, or whether the deal will be an outright sale with a reversion. So the life story agreement may be an option purchase deal, or a sale with a reversion clause included. A reversion clause means that if the rights are not exploited and the film is not made within a certain time period, within a certain number of years, then all the rights would revert back to the subject. And this is so that he can resell the right to make his or her life story to another producer in the future. With all agreements, there must also be consideration. Consideration is the legal term of art, and it's an element for any contract agreement. And the way you'll probably come across many different definitions for consideration, but the way I like to define it is the reciprocal bargain for exchange. And that's what is known as consideration. It's that which is given for something in return. It's usually an amount of money, but it can also be anything of value, including mutual promises. Courts of law, they will not judge value, so long as it is more than a sham. It can't be a sham transaction. To satisfy this consideration requirement and to establish that there is in fact an exchange of value, many contracts will usually recite a provision such as for $1 and other valuable consideration. If there's not a substantial amount of compensation being exchanged, they'll list $1 as the consideration. The amount of consideration, it must actually be paid, and you should keep supporting evidence such as a canceled check as proof of payment. Now, compensation, usually it's a substantial amount of money here. when you're dealing with life story rights. But it varies. There's no set standard for what to purchase someone's right to make their life story. And it varies. Their life story rights may include a flat fee amount. It may be a percentage of the project's net profit. It may also include additional consulting fees and also other types of negotiated bonuses to be paid as the film is exploited in different markets. So that's the consideration provision. There's also the warranties provision. And these are important because this is essentially the essence of the life story rights. These are the promises that must be made in the life story agreement. These are known, this is known as the warranties. And basically the seller of the life story must warrant to the buyer that they will not sue for violation of their right of publicity, invasion of privacy, or defamation. So those are the three legal releases that you want to get: the release of the right of publicity, invasion of privacy, and defamation. Another provision that you may want to include is creative rights, because the buyer of the life story must have the ability to, because they're a creator, a creative artist, you're going to need the ability to embellish, fictionalize, dramatize, and adapt the story. And this is important so that the author or the filmmaker can attract an audience and create an interesting story. Many times the individual may be, the subject that you're doing the life story about may be hesitant, and they may want some sort of control, so they'll insist on having script approval. But the producer will never agree to granting final approval of the script. The filmmaker, the author, that's the creative artist. You don't want the subject to control your creativity. Rather, you can come to other compromises, such as the individual may be allowed to have approval over the treatment or in selecting the writer of the script. You may also allow the individual to serve as a creative consultant to the project, even if the director is not required to accept the individual's suggestions. It may give the individual that sense of security, that they have some sort of control in the direction of how their story is going to be portrayed. Also, you can limit the time, or the individual can limit the time period that's portrayed of their life. And you can also give the individual the ability to determine if actual names of characters are used, or what the screen notice attached to the project will be, such as whether the film will be billed as a true story or a dramatization. But essentially, the creative artist you want to maintain those final creative approval rights.
So it's as we listen to as you review these things, it just comes to me that this is a pretty complicated undertaking, and telling a true story is a pretty complicated undertaking. And can you sort of review like what you might want to do first, like what people should do first, second, and third, and also can you touch on errors and omissions insurance and how that works?
Okay. Well, the first thing I would do is obtain releases. Again,
well, would you do? In other words, would you have? Should people come and see an intellectual property, somebody like you or an intellectual property attorney at the very beginning when they're first starting to put their project together, or should they sort of get to a point where they've got a finished script, which they've written about somebody else, and then bring it to you, or like, and when do they actually need to if they're doing a documentary versus and as told to as opposed to a dramatization, like when do they actually have to start getting their legal stuff together in order to make it so that it's safe for them to produce their thing, and they're not going to get held up during production or find out that their film can't be produced or can't be financed because they don't have the right rights in place, and it just can't be done because you've skipped something.
Right. Early on, I would say consult with an attorney because you don't want to get involved, or basically what the saying is, you don't want to buy a lawsuit. Because I've come on board on projects at different times, and many times it's later, and you are spending so much more time cleaning up rather than if you did it right from the beginning, you'd be saving yourself so much resources. So I would say early on, get the advice of an entertainment attorney to help you with your project. And the first thing I would do is make sure you obtain releases, and you'll want an entertainment attorney to review the content of the releases to make sure they're sufficient. And then also, to obtain errors and omissions insurance, they'll often require that you have the advice of an entertainment attorney. I've handled situations where filmmakers, documentarians about to purchase E&O insurance, and E&O insurance protects you from the risk of being sued for potential claims of, it covers many different areas: copyright infringement, trademark infringement, violations of the right of privacy, defamation, misappropriation, right of publicity. It covers all that. Many times I've come on later, and some of the insurance policies that people are about to buy have a number of exclusions where essentially they're purchasing something that is not even worth the paper that it's on. You're not being protected at all. But I digress. So let me talk about some steps you can take to avoid liability from the subjects that are portrayed in your script or true story film. That's obtain releases, even if it's not legally required. It's best to obtain a release from anyone or anything portrayed in the story, including family members, third parties, locations. The key here is to create a paper trail to basically, CYA, cover yourself, cover your project. You want to be protected. Obtain depiction releases. Written releases are required from all persons who are recognizable or whose name, image, or likeness is used, especially for private individuals who are not public figures and who are also still alive. Moreover, if such a person is a minor, the release must be binding, and that will require court approval. So also, if the subject is deceased, a release usually is not needed, but may be required in some circumstances. Releases are not needed if the recognizable person is only part of a crowd or background shot and is not shown for more than a few seconds or given any special emphasis. That's usually protected by fair use. Nonetheless, it's always best to obtain as many releases as possible. You want to be protected. So have everyone sign releases, even those who are in the background, have them sign releases. Now, the content of the release should be sufficient by, I would say, one, by giving the right to edit and modify the material. Two, give the right to fictionalize the people portrayed. And three, give the right to market the production in all media and markets. You may also want to consider fictionalization. If releases cannot be obtained, consider changing the identity, the names, the location of the people and places portrayed
so that they are not identifiable to any living person by the general public. Now you can include a disclaimer, an express disclaimer stating that the characters are fictional and any resemblance to any individual is purely by accident or coincidence. Now this is not a dispositive factor, so it's not determinative, but it's supportive. Now, most important in your true stories, you'll want to maintain script annotations, and you have to keep all evidence of your sources. You have to maintain all evidence to prove that any alleged defamatory statements are in fact true and to defend against any allegations of invasion of privacy. Now, the script must be annotated by identifying the sources of the information contained in the project. The elements that should be annotated include the characters, the events, settings, and dialogue. The annotations are typically included in the margins of the script or in footnotes or endnotes. Annotations of characters should include whether the character is real, fictionalized, or a composite, whether the actual person is living or deceased, and for composite characters, what is the actual name of the person and what characteristics the character is based. The annotations for scenes should include whether the scene is based on fact, inference from actual facts, what is the source of the information, including books, and if it's a book, you should state the book's title, author, publisher, and the page number that you got the information from. Newspapers or magazine articles, and again, state the title, author, publisher, and page number. Internet sites, stating the web address, the date that it first appeared, if it's known, the author and the title of the article on the internet. Now you may also obtain information from radio or television interviews. So in your annotations, you should state the date of the broadcast, the station, the name of the interviewer, the program name. Other interviews, live interviews, not televised interviews, you should state the name of the interviewee, and then also whether, if any notes or recordings exist of that interview, and whether there's a transcript available and the page number of the transcript. Now you may get information from depositions or court transcripts. If that's the case, you should, in your annotation, state the court, the case number, the date, the name of the witness, the name of the deponent, and the transcript page number where you got the information from. So another step you can get to protect yourself is get a script clearance. Basically, have an attorney provide an opinion letter as to any potential liability before the script goes into production. And again, many insurance carriers will require that an attorney's opinion is given before offering an insurance policy to cover the work.
And you need that. You need that to get distribution. That's if I'm not mistaken. In other words, if you're doing a true life story and you want to be able to sell it to a distributor after the fact, they're going to require errors and omissions assurance, because otherwise they can be prosecuted for.
And then, and then you're going to want the distributor's going to want to be named as an additional insured on your policy as well.
Cool. So that's why it's really important to get to make sure that you, in your script, you've got an annotated script where you've actually said, this is where all of these pieces came from. This is and this is who we fictionalized. This is who where we've combined 2 or 3 characters to tell the story without revealing who they are directly. And this is where we got the magazine articles and so forth. These are the pages, and these are the interviews that we've done, so that when it's all said and done, if there's ever a question going forward, you can always go back to this document and say, this is where whatever elements that's being challenged came from.
Exactly.
Very cool. So the other question is that so I think what we should probably do, because some of the questions that we're getting, we now have some questions that actually come in. Significant number of questions have come in, and I think a lot of them will give you an opportunity to talk about, to review some of the information that you've covered in the context of somebody's actual situation, and then also may bring up related ideas that or other things that you need to let us know about. So is it okay, do you want to move on to asking those questions, or is there some information that we haven't covered yet that you think is really critical for us to go over?
Sure. No, I'll take some questions.
Cool. So the first question we have is, the person asks, I'm co-authoring a book with my mom about her experience living in the United States as an immigrant from India, and many of her stories include folklore and stories that her grandmother told her, and many of these stories are quite common. For example, the mouse and the lion. So how do I cite those stories in my book? Since some of the stories are so prevalent, do I need to track down the original writer or source, or is it okay to reference any source that has those particular stories? Like, I think it's like if she was telling Aesop, she was talking about Aesop's fable or something like that. Does she need to pay someone to recount those stories because she's using the stories in the book, or can she just use the stories? And the second question she asks is, how does defamation apply to companies? In one of her stories, in the book, her parents were living in Memphis, Tennessee, and her father was working for FedEx, and she wants to talk about something that mentioned FedEx to add some context to the story, but she doesn't know. She has to get permission from FedEx.
Mm-hmm. Okay. Well, I'll discuss the first part. The first part, again, the answer is it depends on how it's being used. Now, fair use, this is a copyright issue here. And first, I don't know if these stories are copyrighted. If they're just told, if they're passed down, I'm not sure. But copyright protects the expression of an idea in a tangible medium. So if it was ever written, if you're taking portions of a story that has been written by someone else, that's subject to copyright law, and you'll need to have them give you a license to use their work. However, it depends on how you're using it, because in certain circumstances, you can use another person's copyrighted work without permission, and that's based on the fair use doctrine. And essentially, you can use another person's work if it's not the primary focus. If it's fair use doctrine applies if it's only fleeting, incidental, and not the primary sole focus of your work. I'll have to evaluate that situation a little bit better.
I think it's more like, I think she's basically saying that they have stories that they've had in her country that have been told year after year, like Pinocchio, which is hundreds of years old story, and I think her mother might have told it to her as a story, and it's an allegory for something that happened to them, and then she'd want to be able to talk about Pinocchio because it's part of the story, and I don't think it's a question of it being a derivative work, because Pinocchio is already out of copyright anyway. I think it made the issue maybe how old is the story. And right, I mean, it's because if it's 1 million years old and she's not taking exact language, then it's not like it's a different situation, isn't it? Than if she's actually cutting and pasting copies of an existing story.
Right. No, exactly. I agree. Because copyright law only protects the expression. So if you copy and paste portions of someone's written work, then that would be copyright infringement. Whereas if you're just citing to, or you're writing about a folk tale that's been passed down over generations, it's not protected by copyright. Copyright does not protect the ideas, the themes, the general, what they call the, I believe it's a French term, scenes affaires, general story plots. Basically, it's like the Romeo and Juliet storyline has been told
many different ways, and that has not been considered copyright infringement. It's kind of digressed from her particular situation, but I think you'd be all right, basically.
Yeah. And then when she wants to talk about FedEx, like let's say that her father was working at the company and FedEx was really mean to them. Not that that's the case. Would it be the case that she's allowed to talk about the fact that how FedEx treated her father, or would that be defamation?
Well, again, there is a cause of action known as trade libel, and that's for harm to businesses. So if you are saying that a business's product or service is if you are defaming a business's product or service, you could be liable for trade libel. If you're portraying a business in a harmful, offensive manner that would subject it to lose customers or ridicule for their products or services, you would want to be careful.
Yeah, it's kind of hard to answer without knowing sort of more about the situation, but I think that's a good answer to sort of begin with. Do you want to hear another question, or?
Sure, yeah, I'll take another question.
So there's like 3 or 4 more. So can a story based on historical events be fictionalized or fictionalization? Is it, like, in other words, I think if you wanted to talk about the pirates that used to roam off the coast of Florida and kind of like in the Caribbean, or stories about Huey Long or something like that, they're historical events, but they're about public figures. You can create those kinds of stories without paying special need to worrying about somebody being maligned, right? Because it's if it's relatively old and if it's based upon famous people, then it would be okay for you to do a fictionalized story based upon it. Is that correct? Or would you have to be careful? If you wanted to write a story about Huey Long or something like that, would you have to be careful about not defaming Huey Long even though he was alive in the 1930s?
Well, again, defamation dies with the individual, but you have to be concerned about the right of publicity. Again, it's a newsworthy event, so there must be some form of commentary attached to it. Again, so in this situation, I would say you'd be okay fictionalizing the event.
So if they were doing something about the Twin Towers, and they were talking about terrorists and planes flying into a building, and they wanted to put something on, talk about some manufactured scene that happened on one of the planes that's not based in reality, would that be covered by, would that be problematic, or would it just, or because it's a historical event and you're making up a story about it, you're not talking about anybody in particular, but you're talking about a real life event. Are you allowed to make up anything you want about that, or would you be running into problems because there were real people on that thing and on those planes?
I would say you are able to do that. I mean, the film that comes to mind is Titanic.
Mm-hmm.
You know, that's a historical event and it's a purely fictional story. However, you have to be careful about fictional characters. Because when you're discussing fictional characters, the test is whether a third party could reasonably believe that character is a portrayal of an actual person. So they'll compare the actual person's characteristics with that of the fictionalized character, and that's notwithstanding whether they're deceased or alive. If they're alive, if you're saying that you're using fictional characters, you're still not completely safe. All right, because if it can be identified to an actual person that the characteristics are so similar to the person, then you could still be defaming that person or invading their privacy.
Mm-hmm. Well, you could make up a story about like one of those planes, and you could have a pilot on one of those planes, and it could be a totally fictional pilot, but there was a real pilot. And if there could be any chance of confusion, then that would, even though it's a completely fictional person, a reasonable person might think, but there were really pilots on that plane. So if you're saying that that pilot was a really bad person or, was a collaborator, there's possibility for confusion. So you've kind of crossed the line into something that could confuse people into thinking ill of somebody that was a real person.
Yeah, you may want to consider changing some personal characteristics and traits of the character so that there is no confusion with the actual person. And you can always use a disclaimer, but again, a disclaimer is not dispositive.
It just says you tried, but it doesn't say that you still could have made a horrible mistake and really harmed people. So it's not going to get you off the hook if you really harm people.
Right.
So this one,
also,
go ahead.
Yeah, I'd also like to just throw some also about fictional characters. If you're taking a fictional character from another literary work, infringing, you could be committing copyright infringement because those characters are protected by copyright. So, you have to be careful about having a fictional character that is derived or drawn from another literary work, except, if it's in the public domain or, or if the doctrine of fair use is applicable, then there would be no copyright infringement.
But you'd have to actually see a lawyer. You'd have to see a lawyer to have that conversation. Like when they do those farces where they get like they did that one recently where they had Captain Jack Sparrow and like 25 or 30 other characters from or Hail Caesar, right? Hail Caesar actually has a whole bunch of fictional characters that could be tied back to other films, etc. But because there's so many of them, and because nobody's on screen for the whole time, aren't they kind of considered backdrop characters as opposed to being like intensely derivative and therefore a violation of copyright?
Yeah, it could be argued that the fair use doctrine applies.
Right.
Fair use, again, it's not the primary focus, because the intent of the Copyright Act is to promote creativity rather than to inhibit it. So they want people to borrow from other creative works to create additional works. That's promoting. That's in the Constitution, promoting the creative arts and sciences. We want that. That's progress. But there's a balancing. You can't steal another person's work. You can use some work to create a new work, but you can't just take someone's work and gain from it. There's no copyright. Copyright protects the intellectual labor exerted in creation. So I hope that you and I can't get together and decide to write Harry Potter 8 because that would be completely derivative of the original Harry Potter series. And J.K. Rowling has that right because she created those characters and she has the copyright for those characters and derivative works. But if we were doing a thing about wizards from history and we wanted to show a cameo from Harry Potter, that would be okay because it would be just a cameo, unless somehow or other he's did a trademark or some crazy thing. Yeah, exactly. Yeah, we have to be careful also when you're using the name of a character from another literary work. You have to be aware of trademark infringement, and then also another possible cause of action for unfair competition for passing off as if it's associated with the other Harry Potter's Harry Potter series when it's in fact it is not. You're passing off. You're what they call coat riding. You're coat riding on their good name, their goodwill, their good reputation in order to profit. That's unfairly competing. It's a bad business practice. You're not. That's a violation of the law.
Yeah, you're stealing basically. So the next question we have is, I think you've already answered it, but I'm writing a book based on interviews with live people, and it's about an historical event. And should I get them to sign a release before I record the interview? And I think you'd said that you should record interviews, and then you should get transcripts made, and you should definitely get a release from everybody So is this guy sort of going the right way, you think, or?
Yes. Yeah. I mean, especially if you're going to use the voice of the interviewee in I don't know, I forget if you said it was a film. If it's a film like a documentary and you're going to use excerpts from the interview, definitely want to get a release, a depiction release, including their name, likeness, and voice, and the right of publicity, the right of releasing any claims for invasion of privacy, which includes all those 4 causes of action: misappropriation of name and likeness, false light, intrusion into seclusion, even though that's not very applicable here, and also what were the 4? Let me go over the 4 privacy causes of action again. Public disclosure of private facts. You want to have them release that as well.
Mm-hmm. So I think we've sort of run out of questions, and I mentioned in passing, if anybody sends me an email tonight that, because they realize after hearing the whole call that it turns out they did have a question that wasn't answered, just go ahead and send it to nancy.fulton@yahoo.com, and I'll forward it to Justin. And if it's quick, maybe he'll have a second to respond. I want to reiterate that you can go to Justin's company is called thesterlingfirm.com. thesterlingfirm.com. So you can go over there and take a look at all the different kinds of rights that he can help you with. And the other thing is, I mentioned in passing, you actually do some work. You send me information from time to time about work that you do, where I don't know if it's for free or you basically run clinics. You want to talk for a second about that work, because it seems kind of interesting. I don't know if it's designed to support artists or if it's, but you have a charitable thing you do.
Yes, I would love to. I'm a member of the board of directors for a free legal. It's called the Mesereau Free Legal Clinic. It was founded by Thomas Mesereau Jr., who's been a very good mentor of mine. He was the defense attorney that represented Michael Jackson in his molestation case. He's also represented Mike Tyson, Robert Blake. Recently, Suge Knight, he was his attorney. So he's a famed criminal defense attorney, and he's been very involved in the community with the Women of Watts March. And so he started a free legal clinic. He's been doing it for about 10 years. I've been involved for about 8 years, and we offer free legal services mainly to lower income residents of Los Angeles, but anyone is welcome to attend. It's on select Saturdays of the year. There's one coming up this Saturday. The time is 11 to 2 this Saturday, and it's inside the Morningside Church in Inglewood. The address is 8722 Crenshaw Boulevard, Inglewood, California. And there's attorneys who volunteer who practice in all areas of the law: bankruptcy, immigration, civil, criminal defense. We also focus on record cleaning, expungements. Family law is also there's family law attorneys there. So yeah, it's a great place. If you have any legal issues, it's completely free. We cannot provide representation. We can't go into court for you. That's against rules. However, we can provide you the guidance in order to proceed improper for a lot of your matters. You keep coming back for each clinic, and we'll help you along the way. So it's been a great resource to many of the residents of Los Angeles.
Sounds amazing, and I think it's so difficult for a lot of people who find themselves in bankruptcy, or they're going through foreclosures, because there's still fallout from 2007, 2008, and they just need to figure out how to sort of get get back on track, and they don't have enough money to be able to pay for an attorney. So it's a tremendous value. It's really very kind that your team gets together and helps. Is there a way that you have a newsletter? What's the best way for people to sort of connect to your company so that as going forward they can hear about the stuff that you're working on, and then also I guess they can join your meetup and they can but your company doesn't have a newsletter or anything like that that they can
No, I do periodically. I have a YouTube channel in which I post a lot of videos, civil, videos on civil litigation, entertainment law, intellectual property, business law. So that if you just go on the YouTube and you search for the Sterling Firm, you'll find my YouTube channel. You can subscribe to that. I'm regularly posting videos. Also, if you go to my website, you can sign up for the newsletter. There's a section there. I believe it's on the home page. I think near the bottom you can sign up. And then you'll get on our email list and you'll get some updates when events are being held, when the free legal clinic is being held. So I regularly update people on my email list to what events are coming up.
Well, it's really been amazing. It's like I've been to a lot of events where I've wanted to find out how to actually do true life stories or talk about life stories, and I've never heard anybody talk about a lot of the issues that you raised. And I also think that you've made it a lot clearer about what's defamation versus what's not defamation, and what rights survive death and which rights don't. So I can't thank you enough for coming on, and I hope one day you'll decide maybe we could find other topics that you think people need to address, like, for example, issues of trademark and maybe a talk about trademark and copyright, which are true intellectual property right protections, because I don't think a lot of people realize that when you register your script at the WGA, you're not actually going to get the statutory damages that you would get if you registered it at the Copyright Office. Like, there's all kinds of rights that people don't realize that you have to do something special for.
Yeah, the WGA is good, but it really gives you no legal rights. It just serves as evidence. You really have no legal standing or concrete legal rights unless you register with the United States Copyright Office. Register your script with the Copyright Office, because that will give you three main things. It'll allow you to pursue your claim in federal court. As an attorney, I prefer federal court. It's more traditional. It's easier access. They have electronic filing. It's a better setting. Federal courts have the exclusive jurisdiction over the copyright claims that are for which the registrations are filed in with the government agency, the Copyright Office. And then also you'll get your statutory damages of $150,000 if you can show that the infringement was willful. You'll get that relieves you of the burden of proving damages, which is a great benefit because it's very difficult to prove damages. Take, for instance, a bootlegger on the street selling CDs. How are you going to prove how much he gained? Because that's your amount of recovery is, the gain from the defendant, what he gained from exploiting your copyright. Or the profit, that if you can show what profit you lost, which is really hard to prove. So if you can prove that it was willful, you're relieved of that burden of showing damages, and they'll grant you the statutory amount of $150,000.
But you only get that. But you only get that if you registered at the copyright.gov. If you go up and you registered,
yes.
Otherwise you don't. Otherwise you have to prove how much you were damaged. And that is a huge cost. And it's true. And the fact that people don't know what kind of things you can be registered with copyright, that you can copywriting images versus trademarking images versus copywriting a story versus copywriting a script versus copywriting a film. All of these different, and also copywriting music, and the fact that the music, because I think you also represent musicians, don't you?
I represent all entertainment professionals. I like the creative arts here. I'm located here in West Hollywood. I like to connect with the community. There's a lot of script writers, a lot of musicians, so it allows me to be of service. But I do pursue, the bulk of my practice is litigation. So I do pursue lawsuits, whether it be for intellectual property, business litigation. I also do civil litigation, primarily injuries to others, personal injuries. So I have a wide practice, but entertainment law allows me to connect with the community where I'm located.
Well, that is, I think it's just that you offer a tremendous service, and I think that, and I do hope, I really, honestly, having been to your meetup, I really seriously hope that people do tell them the name of the meetup one more time, so before we go, they have a chance. I really think everybody that's on the call should probably sign up for those meetups, because they do cover stuff that you're not going to hear anywhere else. And the people that are speaking are licensed attorneys that work in those fields specifically, which is a different situation than just going to like the Producers Guild conference or any of these other conferences where you're not actually hearing somebody who does this kind of work every single day. I mean, it's just an entirely different kind of advice that you're going to get. So what's the name of your meetup again?
Hollywood, and the meetup group is named Hollywood Entertainment Industry Meetup.
Cool. So if anybody asks me and if they can't find it, they should just email me, and I'll go ahead and I'll make sure that they get connected to you. But it's because you really do have some great events, so and they're very low cost. I mean, and they're friendly, and the people in them are very friendly. The people that go are really sweet. So it's really excellent.
Oh, it was my pleasure. I had a great time, and thank you. And it was a great experience. Thank you so much.